I, Bhumika Indulia, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to release the book Informational Privacy, Constitutional and Common Law Remedies by Ms. Nina Rohinton Nariman, published by EBC. This book offers a thorough analysis of the right to privacy from a legal and constitutional perspective, emphasizing the need for judicial remedies against privacy violations by private entities. As we gather here today to celebrate the release of this important book, allow me to first welcome the dignitaries on the dais. Justice V. Ramasubramanian. Please join me in welcoming our chief guest for the event, Justice V. Ramasubramanian. He began his career in 1983 as an advocate. He then became an additional judge of Madras High Court in 2006 and a permanent judge in 2009. In 2016, he was transferred to the Common High Court for Andhra Pradesh and Telangana. He also served as the Chief Justice of Himachal Pradesh High Court before being elevated to the Supreme Court in 2019. He retired in 2023 after serving as a Supreme Court judge for 4 years. Sir's love for language is not only visible in his judgment, but also through his contribution to literature. Did you all know that he has authored a book in Tamil explaining the legal principles highlighted in Kamma Ramayanam? We are honored to have you here with us, sir. I request Mr. Aditya Gupta to felicitate Justice Ramasubramanian. Our guest of honor, Ms. Madhavi Divan, is a legal luminary and a trailblazer in the Indian legal profession who made history by becoming the youngest woman to be appointed as an additional Solicitor General in the Supreme Court of India. Ms. Divan has represented the Government of India in several landmark constitutional cases, including Triple Talaq and NJSC, and has also represented various public causes on pro bono basis. Ms. Divan's vast experiences and numerous achievements make her an inspiration to all young advocates who aspire to make mark in the legal profession. We are honored to have you here with us, ma'am. I request Ms. Kriti Kumar to felicitate Ms. Divan. It is now time to introduce the star of the day, Ms. Nina Rohinton Nariman. Ms. Nina Nariman is an arguing counsel practicing in Supreme Court of India and the High Court of Delhi, holding an LLM degree from Harvard Law School, where she specialized in constitutional law. Ms. Nariman is also an avid writer and has written several articles published in SCC, Delhi Law Review, and other celebrated journals. A fun fact about Ms. Nina Nariman is that she loves music. She plays piano and was a part of Harvard Radcliffe Choir. We are delighted to gather here to witness the release of your book. I request Ms. Shubhra Venkat to felicitate Ms. Nariman. Established in 1940s, EBC has been at the forefront of delivering high-quality legal resources to both professionals and students. Under the visionary leadership of Mr. Sudeep Malik, the director at EBC, and associate editor at SCC, the organization has reached new heights in its commitment to excellence. Mr. Malik's meticulous approach is evident in his careful drafting and thorough review of each head note published in the SCC, the preferred law report for both the judges and the advocates. I request Ms. Sonali Ahuja to felicitate Mr. Sudeep Malik. We are also honored to have presence of Justice Nariman and Ms. Sanaya Nariman and request Diksha Dabas to felicitate Mr. and Mrs. Nariman. We are also honored to have presence of Justice K.V. Vishwanathan, Judge Supreme Court of India, and Justice A.K. Sikri. Thank you so much, sir, for joining us today. I would now like to invite Mr. Sudeep Malik to deliver his welcome address.
My Lord, Justice Ramasubramanian, Ms. Divan, Learned Senior Advocate, Ms. Nina Nariman, Learned Advocate, Justice Sikri in the audience, Justice Vishwanathan, Justice Nariman, and a special welcome to Nina's family, Mrs. Nariman, Rohan, her husband, and the children who are the most important people this evening. A special hand for her children, please. and most distinguished ladies and gentlemen, members of this august audience, it's my great pleasure to welcome you this evening to what is really a rather wonderful book. The queue outside speaks volumes. I have never seen this before. That even before the book is formally launched, so many people wanted a copy of the book before it is sold out. So, ladies and gentlemen, what we have here today, the book focuses on something which is a great paradox of modern humanity itself. We have created this thing called social media, a new meta reality. And we are projecting or sharing so much of our personal information in this space. We love to do it, and possibly leaving out some exceptions in the older generations who are not comfortable. If we take younger generations, I doubt there would be a single exception where they are not sharing vast amounts of personal information. And after sharing this personal information, we go, that's too far. I didn't mean to share that much. Or, I didn't mean you to exploit my information in that way. Well, I love to call it the paradox of nudity. How naked is one if one chooses to be naked amongst a sea of naked strangers? And then you say, oh no, I didn't mean to be that naked. So that's one perspective. And the other perspective is what this book deals with, and that is informational privacy. So let me just talk a little bit about what informational privacy is. This is based on an analysis of the idea of privacy, of which there can be so many different views. But this was the first stated by Justice Nariman in Puttaswamy, and then became the ratio later in other judgments. And it's a very useful framework, particularly from the point of view of making privacy actionable. I mean, theoretically, we could go on and on and on. But a huge concern of this book is actually making privacy actionable so that there is sort of actual relief that people can obtain. So the subject matter of this book is personal information and how it might be protected through the rubric of the right to privacy. So informational privacy, of course, even that is a lot deeper and that is discussed in great length, but briefly, it is that aspect of privacy which deals with the protection of personal information that we put out. So the subject matter is personal information that we put out, and in this world, most of it now is on social media. There are other forms of expression which are also covered, but that is principally what concerns us today. And working on this book with Nina has been such a joy. In fact, it started with this brilliant article which was published in SEC. Then she came up with this monograph, which is a brilliant academic work. And then we wondered, how do we convert it into something which is actionable, something which goes much further? On the one hand, she was insistent, I want to retain the academic freshness. But on the other hand, as publishers, but it must sell, it must be of practical use. So it was a very interesting tussle between us. And I think what has emerged is truly wonderful, because legal analysis is something wonderful in its own right. And so many of us here, I'm sure, though our families must wonder what's wrong with us, many of us here just love legal analysis for its own sake. But when legal analysis becomes actionable and a basis for relief, it becomes something truly magnificent. And this is the sort of bridge that this book tries to create between something which is still being understood, which is still fairly esoteric, as the right to privacy, and how it might really be made actionable. What will delight you in this book? I mean, this is a rare book to that extent that it is delightful to read, because Nina has so many nuggets where there's just completely new ideas on things we thought were well settled. And you will enjoy it just for that sake. But you will see that it goes further, as I said, where you will see the emphasis on practical relief. A very interesting analysis is of the intersection of three ways in which personal information might be protected. And Nina argues that there's a great deal of confusion in the law on this. Of course, one is through the right to privacy. Wonder if it will develop into a tort of privacy for civil actions, or whether it's only actionable in constitutional courts. then the well-established thought of publicity, and then even as an aspect of personal property, more personal than one ever imaginal personal property could be. So, if you put out an image of yourself, is it your property, the image itself? Or let's take your Facebook profile, your Insta profile. What happens when you die? Does it belong to someone? Is it property? Is it just actionable in privacy? So these are things she explores, and so many other fundamental issues. So that's the academic pleasure of reading it. The other area where she's done seminal work in this book, and I expect it's another book in the making, is on the scope of Article 226. She's gone right to the very first debates in the Constituent Assembly to support her view that Article 226 needs to be viewed far more widely than it is now. We had some debate over this. She said, no, I'm very sure about this. It's going as it is going. So that you will find terribly interesting, and especially something so new on something we thought well settled. So this book is full of new ideas written with verve, and you will find it very interesting read. Now, just coming to our role as publishers, we do believe, and we've been doing it now for 83 years, and this is the philosophy with which it was founded by my grandfather and his brother in a very heady year, 1942, right? We're asking the British to quit India, and these two young fellows, one of them was 18 and one of them was 28. They decided to do something great because there was a great spirit in the air, something to build, something to create for the nation. And since then, we have been dedicated to publishing the finest manuscripts and making them into even better books, if you will. For after all, a book is the tryst of the author and the publisher with eternity. A well-written book lasts forever. And we do believe that this book will really go very far indeed. And the last thing that I leave you to think about and consider is what happens to all of this with AI sort of now emerging in such a big way. I don't know how many of you watch Terminator and all those Matrix and all those kinds of movies in that genre. I don't know how close that future is. I believe it's closer than we think. But until we get there, and I don't know what will happen then, but for a long time yet, we still believe as publishers that the book as a format, as a format in which it is published, it need not necessarily be in print. Even when you read it in an electronic format like an iPad or any other sort of device that you use, the fixed format is probably one of the finest human inventions for the presentation and analysis of thought. And even though I believe in that crazy future, I believe equally that the book is not going away. Probably AI will also publish books. With that, I hand you over. So, and again, it's a great pleasure to welcome you to the release of a really wonderful book. Thank you.
Thank you, Mr. Sudeep Malik, for sharing this insightful welcome address and sharing the thought on the beauty of the book. I would now like to invite Ms. Divan to enlighten the gathering.
I'm actually already seeing a very enlightened gathering. I'm not sure how much I can enlighten you, but here we are, and I'm absolutely delighted to be here. It's a very, very happy occasion of the release of Nina's very first law book, and I'm sure this is going to be the first of many more in the making. Book writing, as I have discovered, and that's what Nina and I have in common, our common publisher. Book writing, and particularly law book writing, is very hard work, particularly for a practitioner. And what no one warns you when you embark on a project like this is that law books, unlike other books, are, you can't put it away and say, okay, I'm done with that and I'll move on to the next. It doesn't happen like that. A law book stays with you. It is always going to be work in progress. And, with the kind of developments and the kind of the kind of subject that Nina has chosen, which is a very exciting, cutting-edge subject, it's going to move swifter than we can speak. And therefore, I can see many, many sequels already in the making. Um, so, while at a first glance, the subject may appear very niche and specialized, it's actually front and center. And there can be actually nothing more front and center than privacy or informational privacy in particular, because this is a value that really pervades our daily existence today in many more ways than we even recognize or know. And it is on our ability to protect informational privacy that hinges our enjoyment of many other fundamental rights. So, and many other values under the Constitution, whether it's human dignity, the liberty of thought, the freedom of conscience, the freedom of movement, um, identity, self determination, free speech and expression, and the freedom to make choices. And I often ask myself that the violation of and the onslaught actually on informational privacy is taking away from human beings something which is so innate to human beings, and which what really sets us apart from every other species, which is the freedom of thought. And without the freedom of thought, I mean, what good is, for example, the freedom of speech and expression? What worthwhile opinions are we going to voice without the freedom of thought? And this is what, in the age of data mining, what is being taken away from us, what is being robbed from us, in ways we don't even want to recognize, is our ability to think freely, minds free from manipulation. That is perhaps a thing of the past now. Um, Lately, what's been in the news is something that went viral called it was the Ghibli craze. And this is, of course, the Studio Ghibli style art, which is available on Chat GPT. And I was reading a little bit about it. And this is a feature which allows users to transform their own photographs into the signature aesthetic of a legendary animator, Hayao Miyazaki. And this really went viral with millions of users across the world uploading pictures to get animated selfies, memes, family photos, and so on, all in the animated version. The debate over Ghibli has really been in the nature of what impact this is having on the real world art, as in, art is meant to be personal, subjective, innovative, imaginative. And it is now being replaced by this mass commodification, this mass automation. But some have also, rightly so, raised this a serious alarm about the invasion of privacy, of data privacy and security risks. But what is really troublesome is the ease with which tens and of thousands of people are quite happy to upload their photographs and effectively surrender their personal data just for a kick. I mean, this is quite different from a utility which you are gaining in terms of, a convenience or something that saves cost or time, for instance, a Digi-Yatra. I mean, there are problems with that too. But when you share your location, say on Google Maps, there is a convenience to be taken. And I'm not saying that they will not share. Of course, they share your data and they misuse it as well. But at least there it is for a convenience. Now we are willing to make that trade off just for a lark. And this normalization, this very normalization of the surrender of personal data, which can be very seriously misused, is very problematic, which shows that as an educated generation of netizens, we have really surrendered our ability to think for ourselves. Now, a lot of this information which is being shared, these photographs, millions of photographs are just being uploaded all the time for this Ghibli animated art. And this can be used, for instance, to create fake images, fake evidence, become fodder for scams, for defamatory content, for targeted hate speech, and worse even, revenge porn or sextortion. All of this becomes much easier with this kind of personal data available out there. So this is, I think, that the troublesome thing that we have been lulled into, and if I may say so, dulled into a sense of such unquestioning complacency, where we simply follow the herd and exercise less and less independent thought. And the dependence on these platforms is so abject that human beings are not even challenging themselves to make informed choices. We've become so accustomed to what we believe, and very mistakenly so, we believe these are free services. But what we are trading off and what we've numbed our minds to is the actual costs that we are paying in kind, which is through a barter of our own privacy, our personal data, which is actually far, far more costly than what we would have been paying in cash. And this is a cost which we haven't yet even begun to account for. We live in what is famously called the attention economy. There is such an overkill of information around us that human attention itself has become a scarce commodity. So scarce a commodity that it becomes a valuable economic resource to be monetized. The big tech companies compete for user attention using very sophisticated algorithms and data analytics to capture and retain attention, and even to steer preferences in a particular direction. So, this is the irony. Our own data is being used against us to mold our choices and to steer them through digital nudging in a different direction. And so this very business model of this economy is surveillance. And I remember that about, I think it was 2016, when we were arguing the WhatsApp privacy case before Maninder is here, before a constitution bench of the Supreme Court. It was in the summer vacation. And one of the things that I mentioned to the court was that, look, this is the very business model. And I remember one of the learned judges remarking, and I now realize that we were so kind of, divorced from reality at the time. And he said, so how are you concerned with the business model? But this is the whole thing. Can you have a business model which is really modeled on preying off personal data, and that too with such great opacity involved? And while we imagine that we are consumers of information, which of course we are, but paradoxically, it is the consumers, you and I, who are being consumed in this process. We are the products who are being offered to advertisers, who in turn, of course, monetize this by selling it to governments or, of course, for themselves. And therefore, this can be used for anything to mold product choices, anything from product choices to electoral choices. And we've seen how governments over the world have been using this data. Elections have been subverted in several countries, and this is all documented, Cambridge Analytica and all of that. So these gains, actually, it's interesting that I've read more than once that this big tech is comparable to the East India Company of the past. And except that the East India Company was indulging in creeping acquisitions of territory, whereas this is a creeping control of the mind, which is even more dangerous. Now, when we talk of, say, national security, look at the United States of America, where the example of TikTok, where the US Supreme Court actually upheld a ban by the Biden administration on the grounds of national security. And the ground was that that TikTok was designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance to capture the personal data of US TikTok users. So, there are so many ways in which the world is responding, somehow, very ad hoc in some ways. For instance, in Australia, they've imposed a blanket ban on social media use by teenagers, and that is going to come into effect later in the year. That was, of course, the question was, are you throwing the baby out with the bathwater? But for instance, in the United States of America, tens of schools have filed class action suits against the big tech giants for a staggering amount in damages for the mental health crisis that they have caused to young people. And their claim is that, look, their case is that, look, your platforms are by design and fabric intended to be addictive. So that is what is causing this awful mental health crisis, and of course, this, the distraction, the ability. So they are like the Pied Pipers of the modern day. Given how pressing this issue is, it's actually a matter of irony that it took us such a long and checkered battle to really ensure that privacy was declared, the right to privacy was declared a fundamental right. That was Mukul is here, I think. Yeah. So it was a long and difficult struggle. But what Justice Nariman delineates in that judgment is three facets of privacy. One, of course, is relatable to the physical persona of an individual. That is his name, his likeness, his physical attributes, his voice, for instance. And that, as I will mention, is much easier to, it has its own challenges. For instance, with AI particularly, the problem has been exacerbated because you're having, deep fakes and all kinds of unauthorized use of people's attributes. So but the high courts are responding. So you have judgments, for instance, in the Anil Kapoor case, the Karan Johar case, and recently a couple of doctors of some eminence have actually successfully managed to contain the unauthorized use of their images. But when we come to the other two aspects of privacy, which he talks about in his judgment, one is, of course, informational privacy to do with the mind, and the third is the autonomy of choice. Now, these two are linked. And because of the opacity of these tech giants and their privacy policies, it's very, very difficult to penetrate that veil and see what's going on and effectively come up with remedies. So this is Nina's book is, of course, about remedies. And she provides some very interesting solutions. She is suggesting, she talks about the constitutional torts, about the horizontal application of fundamental rights, for instance, as recognized in the Kaushal Kishore case. That is to apply this principle, to apply, writs can be filed against private corporations too, or can be extended to private corporations, or to insist that the state acts. The state is under a duty to act against private corporations for their failure to follow proper privacy policies. But this is really going to be a bit of a contradiction in terms, in as much as if your very business model is the violation of privacy, how are you going to change that? There will be no business left if the business model goes. So that's going to be quite interesting. But Nina offers some interesting solutions. There are other options also available. Ideally, there should have been remedies available in consumer protection, but we are in that department. I think we have been quite slow. But for instance, competition law, that will also offer some solutions, because these are issues, given the scale of what is happening, needs to be dealt with at a macro level. So you have, for instance, a few dominant players who are controlling the market. And this is actually a textbook case for abuse of dominant position. So the more data you get, and that is possible through, for instance, the interconnected common ownerships, for instance, WhatsApp has with the others, or through mergers and acquisitions, or simply by driving out competition. So this is how they gain control over mass data, and he who can maximize the collection and collation of data is really the winner in this market. So this is what becomes fertile fodder for both advertisers and governments to use data about citizens. Another remedy would be, I think, to extend the principle of the right to be forgotten. Many of you would remember this principle, which has been recognized by our courts across India. And what it simply says is it derives from the right to oblivion, which is to mean that data about you or information about an individual, for instance, an old criminal record or a soured relationship which has no relevance to the present, should be deleted or effaced from the public domain so that no one has access to it. But perhaps this principle could also be extended to algorithms, that the algorithms themselves too should be compelled to delete their memories so that they cannot store or collate data about individuals. So this is something worth thinking about, and given how slowly the law works and how swiftly the market is moving, I think it's very important for the courts also to catch up and to be able to fashion new and innovative remedies. In the end, I will say that, Nina, congratulations, a huge, big congratulations. I think in writing this book, she has shown that she's a chip of the old block, and also that she might be the youngest Nariman to have yet authored a law book. So that's a big feather in her cap. But apart from that, she's been a very active, to do it while being a very active practitioner and a very able parent to Zarina and Cyrus, who look very happy today, and some of the credit is theirs too today. But at the cost of breaching her informational privacy, if I may just say that she's, apart from all her other talents which were mentioned earlier, she's also a keen horticulturist, and she grows these really stunning orchids. And so today I wish her many accolades and orchids, and may this be the first of many books. Thank you very much. Thank you.
Thank you, Ms. Divan, for that enlightening speech. Your thoughts have given us a deeper appreciation of themes and ideas around privacy. So, the moment we all have gathered here to witness has arrived. I would now like to request the dignitaries on the dais to please release the book, and also request Mr. Sumain Malik, Mr. Surain Malik, Mr. Sumit Malik, and Justice Nariman and Mrs. Nariman, please come on stage to release the book. And Mr. Karan Malik, please to come on stage. What a momentous moment to witness. Keeping the momentum on, I would now like to request our chief guest for the event, Justice Ramasubramanian, to please share his insightful address.
Ms. Madhavi Divan, Ms. Nina Rohinton Nariman, Mr. Malik, my good friend and former bench partner, Justice Rohinton Nariman, Sanaya, Justice Vishwanathan, Justice Sikri, learned advocates, dear friends. Normally, I am not a very serious person, so I would not talk on high philosophies of law, because at the end of the day, I would all like you to be awake and go home. Generally, I go extempore, but on a topic like this, and on an occasion like this with Justice Nariman sitting in front of me, I thought I would use my discretion to prepare a text so that the informational privacy of mine is not infringed. On 29th March, Saturn transited from Aquarius Kumbha Rasi to Pisces Meena Rasi. So when I woke up on 29th March and I opened my mobile phone, there were at least 100 suggestions as to what I as a Scorpio should do on such an occasion. In fact, my star is such that 3/4 part of it falls in Libra and the last part falls in Scorpio. So when I saw that all the suggestions pointed out to the pariharas to be done for Scorpio, I realized that Google knows my horoscope very well. Therefore, I always tend to think that Google knows much more about us than our own spouses do. It is in this context I think informational privacy is very important. Just see, this is the way to teach informational privacy. You must tell them what they like. Mr. Malik talked about the paradox. What is the paradox? The paradox, in my opinion, is actually twofold. One is that when you enter the social media, you must realize that at one and the same time, you are the consumer as well as the product offered to somebody else. This is the paradox. In real life situations, either you can be a producer or a consumer. But in social media, you become a combination of a consumer as well as a producer. Therefore, the first lesson that all of us should learn is that when somebody offers you some services free of cost, he is actually offering you for a cost to somebody else. If this underlying principle is understood, I think probably all of us will maintain what is now called as digital hygiene, which we don't. Mr. Malik also talked about days when artificial intelligence will write books. I was surprised that he does not know that artificial intelligence has already started writing books, but in the name of some authors. I should not say this, but I can't resist my temptation to say this. AI has already started writing judgments also. But fortunately, today this book is written not by AI, but by NI. What is NI? Native intelligence. The second paradox about this is that all of us want our own privacy kept intact, but we are interested in peeping into the lives of other people through social media. I had a very, very sad case where I was a judge of the Hyderabad High Court. A very famous actor of yesteryears died in a road traffic accident. When his body was brought to the hospital in Hyderabad, the next day, there were a lot of photographs of the nurses working in the hospital taking selfies with the dead body and circulating. This is the extent to which we have gone. Therefore, I always think, is it fair for us to blame only the tech giants when we have not kept our conduct clean? We do not mind peeping into the lives of other people through social media, but we want our privacy intact. This is the second paradox. We all know that the journey of the right to privacy commenced perhaps when Sir Edward Coke said in 1604 that every man's house is his castle and fortress. There was a very interesting statement made by a New York University Law School professor by name Bernard Schwartz. He said, "Our house may still in theory be our castle, but that castle no longer sits on a hill isolated by a moat. The modern castle is connected to a central water system, to a sewerage system, to a garbage collection system, and more often than not, to houses on either side." Fortunately, it was not when he wrote it, the age of internet had not begun. Otherwise, he would have said it is also connected to the internet. Therefore, every man's house is no more his castle. This is why in 2000, the CEO of one of the leading companies, Sun Microsystems, declared, I have written it in my message, that privacy is dead with the advent of internet. Get over it. He said it in 2000. When Nina invited me for this book launch and also requested me to write a message, I was wondering why me. She could have invited persons who are intellectually more sound and strong than me. Then I realized perhaps there is a causal connection. The connecting link for this book, I would put it this way, the connecting link for this book is from Ro to Ram. I'll tell you why. If you carefully go through this book, you would find that it is Justice Puttaswamy's judgment that must have triggered Nina to write this book. And this thought triggered by Justice Puttaswamy was fueled by Kaushal Kishore. And Puttaswamy's author is sitting here. I mean, one of the authors of Puttaswamy is Justice Rohinton Nariman. And the author of Kaushal Kishore is me. And that is why I say this book is a journey from Ro to Ram. If you look at the data now available, just see what regulators have done the world over in the past 1 year or 2 years. Several countries in the European Union have woken up to the reality. And if you look at the fines imposed upon these big data companies, it is mind-boggling. Under the European Union's General Data Protection Regulation, the Irish Data Protection Commission imposed a historic fine of 1.2 billion euros on US tech giant Meta for transferring personal data of European users to the United States without adequate data protection mechanisms. On July 16, 2021, the Luxembourg National Commission for Data Protection issued a fine in the amount of 746 million euros on Amazon.com on a complaint filed by 10,000 people in May 2018 through a French privacy rights group that promotes and defends fundamental freedoms in the digital world. On September 5, 2022, Ireland's Data Protection Commission issued a 405 million euros GDPR fine to Meta Ireland concerning the lawfulness of processing children's personal data. On October 30, 2024, the Irish Data Protection Commission fined LinkedIn Ireland 310 million euros for GDPR violations on a complaint filed by the same French non-profit group that revealed LinkedIn's misuse of user data for behavioral analysis and targeted advertising. So the list goes on and on. So where do we stand today? We have not come to a stage where privacy is still dead. Only a wake-up call has been given. As somebody else pointed out, It may not be dead, but it is still on life support system. In fact, I told Nina when she wanted me to write a message and launch this book that my best of times on the bench and the not so good of times for Rohinton happened at the same time. That was the time when both of us shared the bench together, and we shared a lot of. In fact, he added a note of caution when I came here. Ram, don't go too humorous. You may not get a bail. This to come back to this book. This actually, what constitutes a good book? I think all over the world, people have identified 5 characteristics of a good book. They are: number 1, it must have a clear premise. Number 2, there must be a clear process. Number 3, there must be supporting statements. Number 4, cohesive structure. Number 5, a solid takeaway. In other words, it should not be like a judgment. This book of Nina is divided into 9 chapters. The first chapter traces the history of how the common law, which originated in England, is considered so flexible even today that in 2012, the Law Commission of England thought that there was no need for legislation for dealing with smart legal contracts because the existing common law is sufficient to take care of emerging trends. They thought it was so elastic. In the second chapter, Nina discusses what constitutes privacy and how the law has evolved in 3 different time periods. From a very simple statement of Warren and Brandeis that privacy is to be let alone in the 1890 article, to its development in 1960 into 4 different thoughts by Professor William Prosher, namely intrusion upon seclusion, public disclosure of embarrassing private facts, placing a person in false light in public eye, and appropriation. Then the third time period came Daniel Solovey, who, according to Nina, is the current generation's Prosser, who identified 6 trends of privacy in his articles in 2002, namely right to be let alone, limited access to the self, secrecy, control over personal information, personhood, and intimacy. As the law kept evolving, the decision in Puttaswamy came articulating spatial control, decisional autonomy, and informational control as the 3 broad heads under which privacy can be understood. The third and fourth chapters of this book deal with the right to privacy as developed by courts in US, Canada, Australia, South Africa, and the UK. The fifth and sixth chapters discuss the common law, the inadequacies of the common law in dealing with privacy concerns, and the tort of publicity. The sixth chapter is quite interesting as it deals with personality rights in the context of celebrities and non-celebrities. In fact, there is a discussion about one of the cases that came up before the Madras High Court. The film was titled Mehu Rajnikant. Interestingly, the case was filed not in the name of Rajnikant. It was filed in his personal name, Shivaji Rao Gaikwad. The court said that you can't use his name and image and show him in poor light because he has acquired a celebrity status. Therefore, Nina compares this case. Nina wonders what would have happened if Shah Rukh Khan had gone to court. Because Shah Rukh Khan's screen name and personal name remains the same, whereas Rajnikant's name is different. His personal name is different from real name. And the question is whether it applies only to celebrities. Why not to non-celebrities? That's a very interesting chapter on the sixth chapter. Then the seventh chapter proposes the development of a new tort remedy for the right to privacy in the context of Puttaswamy. The eighth chapter traces the history of Article 226. In fact, while tracing the history of Article 226, I read a very interesting statement made by Sarvapalli Radhakrishnan while addressing the Constituent Assembly. I think it's at page 160. Let me check. Yes. This is what Sarvapalli Radhakrishnan said on when the objectives resolution was moved. Sarvapalli Radhakrishnan, in his own inimitable style, said, I quote, "It is a socio-economic revolution that we are attempting to bring about. It is therefore necessary that we must remake the material conditions, but apart from remaking the material conditions, we have to safeguard the liberty of the human spirit. It is no good creating conditions of freedom without producing a sense of freedom. The mind of man must have full liberty to flower and mature and to grow to its fullest stature. Therefore, look at his prophetic words." Nina says Radhakrishnan's words became almost prophetic when it comes to the interpretation that the Supreme Court of India has given to the right to life and liberty. And another interesting portion where Radhakrishnan takes a dig at Winston Churchill. It goes as follows. This resolution about the Indian Republic seems to have irritated Mr. Churchill and its followers. When the debate on Burma took place, Mr. Churchill stated that the annexation of Burma happened during his father's secretaryship and that now Burma is given the liberty to get out of the British Commonwealth. He seems to look upon Burma, that is Winston Churchill, seems to look upon Burma and India as parts of his ancestral estate, and now when they are passing out, he seems to be terribly disheartened. The caliber of men who occupied very high positions in those days, that is reflected in the way they put across things. After all, I always remember what, I think it concerns Settlewood. When an youngster at the Bombay High Court said something very offensive to the judge initiated contempt proceedings. I think it was Settlewood. When Settlewood went in defense of the young man, the judge asked him, "Do you justify the conduct of this young lawyer?" Mr. Settlewood said, I think it is Settlewood, I don't remember. Daftari said, that is why you must be a partner of a bench. Which contains a person who remembers. Then you can escape many. So Daftari said, my lord, I don't approve of the conduct of this young man, but please remember, he is an youngster. Therefore, he has done the right thing in the wrong way. When he reaches your lordship's age and my age, he will know how to do the wrong thing in the right way. So all these 9 chapters, in fact, the first chapter is about thread and patches, correct? There is a common thread. I thought about this book as just like this. There is a common thread running, in a sequence from chapter 1 to chapter 9. But it also contains patches because if anybody wants to read one particular portion, they can read it and take the best out of it. So this is the utility value of a book. If a book has got to be read in full, then I don't think most of us don't even read WhatsApp messages unless they concern somebody else's life. So it is very difficult for people now to read the entire book. A book should have a thread running throughout, and at the same time it must be in patches. That is the first chapter. The title of the first chapter is Thread and Patches. So now where have we come on this question of informational privacy? I will just narrate a very recent decision of the Inter-American Court of Human Rights. In the decision of a decision rendered at the instance of Lawyers Collective, not Lawyers Collective of India, Lawyers Collective of the American courts. See, what happened was in April 19, 2011, in fact, I was happy for different reasons while reading this judgment. It took 22 years for the Inter-American Court to decide this case. So I was very happy because nobody can blame me. On April 19, 2001, the Inter-American Commission on Human Rights received a petition lodged by they call it, I don't know how to spell it, Jos Elvier Restrepo Lawyers Collective. Huh? What is that? Why don't you give me the advantage? And the Center for Justice and International Law, which alleged international responsibility of the Republic of Colombia for the alleged attacks, acts of intimidation, harassment. You must read this judgment. Towards the end of August 1999, copies of a pamphlet signed by the Colombian rebel army were distributed in a number of public places in the city of Bogota. The pamphlet threatened with death public personalities, intellectuals, and social leaders, including Alirio Uribe, a member of the Executive Board of Lawyers Collective. Since that date, according to the petitioners, Alirio Uribe has noticed that he has been followed on different occasions, in particular by strange men on motorcycles without number plates, received visits to his office by suspicious persons, somebody wanted to give him some gift, etc. On another occasion, on May 13, 2005, upon arriving at her home, the then president of the Lawyers Collective, Arguello, received an unusual package left at her residence by a private mail delivery company, which was opened by members of the National Police for fear that it might contain an explosive device. Inside the package, there was a beheaded and dismembered toy doll, daubed all over with red nail polish as if to resemble blood. And there was a handwritten note: "You have a beautiful family, take care of them, don't sacrifice them." So many such instances were brought to light. Ultimately, 2020, the Inter-American Commission submitted a report on which the Inter-American Court of Human Rights issued a historic judgment on 18th October 2023. What is important about this judgment is, this judgment has advocated two things. One is, it held that the Republic of Colombia is internationally responsible for human rights violations against several members of the human rights group. The second is that this judgment talked about the way in which personal rights, this informational privacy right, can assume not national but international ramifications. And that case perhaps requires a deeper analysis, like by persons like Nina in her second edition of the book. I hope she will. I was really surprised to see such a huge audience for a book launch function. Normally, for a book launch function, there will be a lot of children because the family members have assembled in large numbers. But today, apart from her family members, I see such a huge gathering, all of whom constitute, I think, the extended family of Narimans. Therefore, my heartfelt congratulations to Nina for such wonderful book. And I will not say chip of the old block. In fact, Rohinton does not like being called chip of the old block. Therefore, why should I call Nina chip of the old block? You have your independent mind, you have your independent thinking. You will do well. Thank you.
What a delightful address. And thank you, sir, for teaching informational privacy with your wit and humor. We truly appreciate laughter and the fresh perspective you brought. Now we have with us Justice Nariman, and considering he is here with us, we do not want to miss hearing from him, and hence I request sir to please say a few words.
Very difficult to say anything after such a fantastic speech by both of you. Wonderful. I can only say that from my Nina's birth, I have been very, very proud of her. I continue to be very proud of her. She has been a model daughter. She has been a model wife. She has been a model mother. So, having these three models in front of her, how she's turned out to be a model lawyer is anybody's guess. I can only say one thing, that in the remedy that should be forged, which is your last chapter, I see no reason why Article 226 cannot accommodate a court, a writ court, enforcing a fundamental right. Now, true, fundamental rights are usually against state action, but that's only for the purposes of Article 32, which itself is a fundamental right. 226 is advisedly much wider because from the very beginning, we have had articles like Article 15.2, 23.2, etc., which are meant to be enforced as fundamental rights against other citizens. Now, how are they going to be enforced unless it's enforced in 226? You can't force people to go to suits in civil courts. So, according to me, it's very important that a 7 or 9 judge bench revisits this public aspect doctrine under 226 and confines it to non-fundamental rights. Because the moment you say there is a fundamental right, the right is no longer fundamental unless there's a remedy for it. So I think the time has come now, and I hope this book is a catalyst to tell the old folks where we were to start moving along these lines and now say that 226 should be a remedy in the writ jurisdiction to enforce fundamental rights of one citizen against another. Thank you all very much.
Thank you so much, sir, for your address. Now it's time to invite Ms. Neena Nariman to share her thoughts on the occasion.
Thank you all for being here. So I was planning on talking about the book a little, but I think it's pretty much been covered by everyone. The bit that I actually like the most about the book personally is what my father was just talking about, which is the 226 jurisprudence, because traditionally it's known to be only against the state. They thought they were expanding it by saying that it's not just the state, but also these other authorities controlled by the state. The premise in the book in the last few chapters is to say that 226 has been unnecessarily confined within the rigors of what was meant only for Article 32. It should never have that jurisprudence in Article 32 being part of Part 3 in the Constitution. Sorry, I'm talking only to the lawyers here. I also have some non-lawyer family sitting here. But so the part that is most dear to me in the book is actually that last chapter, which I hope will provoke some thought because it's entirely unorthodox. The orthodox view is an entirely different view. So aside from that, I'd just like to thank everyone for being here. My mother and my father first. My mother has followed in the tradition of the Nariman ladies being the backbone of the family. Yeah, absolutely. My father is an absolute genius. I don't think the legal community realizes the level of genius he is. And his moral upstanding as well, which is incredible. I also need to thank my in-laws for being here. They are immense support. And my children, of course. And I've my sister, who's my best friend. And I've left the best for last. My husband, Rohan, who none of this would be possible without. Thank you all for being here. It means a lot. Thank you.
Thank you so much, Neena, for choosing EBC as the publisher. I would now like to invite Mr. Sumit Malik, Associate Editor, Supreme Court Cases, to deliver a vote of thanks.
Good evening. Just falls on me to deliver this vote of thanks. My first thanks goes to Justice Ramasubramanian and Ms. Madhavi Divan, our chief guest and our guest of honor. Thank you for taking out the time, for being here and enlightening us with your wit, humor, and your erudition. My thanks to Neena. Thank you for reposing trust in EBC. My thank you to all of you who have taken out time to be here at this occasion. There are also sort of a book like this come out of GPT. So there are a few people who've sort of worked really, really hard, whereas Sudeep worked with Neena in terms of the conceptualization. Nilofer Bhateja, who's the legal editor for this book. Today at 6 in the morning, she had to be told to go back home because with fever, she wanted to come here and be here. I said, no, that's fine. And she's sort of been constantly working with Nina to get this out. The team of all the copy editors, the proofreaders, the DTP operators who worked to sort of produce this, printers who sort of helped bring this out, and then those who helped in organizing today's event, that is the team of Nilofer, Prachi, Bhumika, Kriti, Diksha, Shubhra, Sonali, who've worked tirelessly behind the scenes. Thank you for organizing this. Now I invite all of you for high tea, and once again, thank you all for being here.